Welcome back to the Scholar Wealth Podcast. This week, we begin by discussing how to think about concentration risk after significant gains in large cap tech and AI related stocks, and what disciplined rebalancing really means in that context. Next, we examine healthcare planning after financial independence, including whether pairing catastrophic coverage with concierge medicine is a rational balance sheet decision. Finally, we're joined by Ellen Morris, Chair of Fiduciary Litigation at Cozen O'Connor, for a conversation on how thoughtful planning, documentation, and communication can help families avoid some of those common trust and estate conflicts. So let's go ahead and get started with question number one. So question one here, about 3 years ago, I had roughly 25% of my $6 million portfolio allocated to large cap tech. After the recent run up in AI related stocks, that sleeve is now closer to 42%, long-term oriented and don't want to react to headlines about an AI bubble, but that level of concentration makes me uncomfortable. How do I trim this back without feeling like I'm trying to time the market? So this is a question that keeps coming up more and more, especially the market keeps going higher and higher. And you're not wrong to be a little worried about all this. I mean, if you look at any historical metric or any of the economic indicators around market valuations, they're all high. This is a concern. But the problem is that the market can stay high for a long time. So it's not necessarily market timing. What you're talking about is rebalancing to what you started with for your allocation. It just so happens that you haven't done that in the past few years. So now it's gotten out of whack. So your risk is actually increasing the portfolio, which is exactly why you want to rebalance regularly. So I would go back to that original target allocation and say, does it make sense for me to have 25% in large cap tech? And if that is still yes, and you agree with the overall allocation that you have, the big pie that you have that you're dividing up, then I'd say it's not a rebalancing decision, or it's not a market timing decision. It's a rebalancing decision. You're just going and pulling back to 25%. Again, I think the issue here and where you're getting some of that kind of where it feels uncomfortable is because you could have taken 25% and then a year later pared it back down to 25% and then it went up again and then you keep pulling it down to 25%. Unfortunately, what ends up happening is if we let it run for a long time, it starts to get so far out of whack where it starts to feel more like market timing because now you're going to rebalance at a time when the market's high. So it's not that you're not rebalancing. I think there's a little bit of market timing in here, right? That you're dealing with, but I think the market timing aspect is more like rebalancing timing. That you're saying things are getting a little out of hand. Time for me to do something, and you don't want to feel like you're going against your kind of core investing values that you're a long-term investor and you don't market time. So if you want the kind of the permission to do that without feeling like market timing, I think you're good to go and rebalance the portfolio back to that 25%. As long as you feel that 25% still makes sense. That's where you start from the basics, look at that allocation. And when you build out that allocation, I always look at allocations as turning a cruise ship around as opposed to a jet ski. So if you have your allocation that's being built, you don't just go from 25% large cap growth to 40% large cap growth on a whim. That's got to take, you have to have a really good economic thesis for why you would want to make that big of a shift in your portfolio. And that's what should drive those shifts in the allocation. The problem you may run into, and I don't know based on this where your assets are located, but based on that $6 million and this move to 40% down to 15 or 25%, you're going to have to cut about 15% here. So there's a significant amount of money. You're looking at $900,000 that we're going to be dealing with in this scenario for rebalancing. That worries me a little bit if these assets are being held in taxable accounts, which based on the account values probably is the case. So you're going to have to, you've kind of got yourself into a little pickle in that scenario where you're going to have to be careful to evaluate whether or not it makes sense for you just to go today and sell all of those stocks at $900,000 or so of the portfolio and rebalance and take the tax hit, or does it make sense to do so slowly or use any tax deferred accounts that you have to balance out some of those growth holdings if you can pull them out of there? One thing I'd tell you to look into is some different types of index funds that would give you exposure to large cap growth and large cap value to balance that to get you to the S&P 500, which sounds like you probably already have since you're talking about that particular exposure of large cap tech increasing. So I don't think it's necessarily a bad thing. I don't think there's any issue with you rebalancing. I wouldn't call it short-term market timing as much as it is going back to what you already agreed upon was a good allocation for your portfolio. And for our next question, my wife and I are in our late 40s and reached financial independence with about $11 million invested assets. We left traditional employment a few years ago and no longer carry a comprehensive health insurance plan. Instead, we have a high deductible catastrophic policy with a $25,000 deductible and a $1 million coverage cap, and we self pay in cash for everything else. We are considering moving to a concierge practice with a joining fee and a $9,000 annual retainer per person, which would bring more direct access to physicians and longer appointments. Is this a rational trade-off in our situation? So we have a couple different things going on. So we definitely want to take this apart a little bit. One thing is the combination of concierge medicine with a health insurance plan, a catastrophic type plan. Very common. I don't see any issues there. I don't think that you having concierge medicine is necessarily a risk transfer situation. In other words, you're not changing your insurance coverage there. What you're doing is just adding different types of services or a higher quality of service that's a little bit more flexible, a little bit more personalized. So all of that sounds good, right? I don't see that. And it's a very common move, especially at that above $10 million mark for investments. Not surprising to add that level of service in there. What I'm more concerned about, and I guess before we even get into that, the $25,000 deductible, also not a concern, right? That's going to be normal. I don't see it, especially for a high deductible plan. And for your level of net worth and assets, $25,000 can be a rounding error. It's not a concern. All right. So there's no issue there. Out of all of this, the concern that I have is this $1 million coverage cap. So $1 million coverage cap tells me that this is not an ACA compliant plan because you can't have the coverage caps there, which means you're likely dealing with some of these other, I, I'd call them like healthcare adjacent situations, like health sharing types things. The one that this sounds most like, which is likely the case that you're dealing with, is like a health sharing ministry where basically everyone's pulling together this risk sharing of you submit your medical payments and then everyone else in the group pays for them. And when they have medical payments, they submit and everyone else pays for them. So everyone's helping each other out in this scenario. Those sound good at first. The problem you run into is there's no legal obligation there to pay this. And they typically have caps, just like you're seeing with this $1 million catastrophic cap. That's what worries me of all the things here. Because could you handle a $350,000 hospital bill? Absolutely. Could you even handle maybe a close to $1 million cancer treatment, right? Absolutely. But what the problem is, if you're truly wanting catastrophic caps or a catastrophic coverage, what would absolutely wreck your finances is $3 to $4 million of multi-year care for a health condition. That's what will absolutely take this 11 million down really fast. And that $1 million cap, you're going to blow through that without a problem. So you have to start looking at whenever you're dealing with any type of insurance, you're always looking at the probability of that event happening and the cost or severity of that event and trying to pull those two things together. In a scenario like this, low probability events, you start to either go into a self-insurance mode, which could be good, or you go to have that insured. So this is like, think of this as a flood insurance type scenario. Major event, low probability. So that's something you insure. You don't take that personally on here. That's exactly what you're talking about now. Low probability of something major happening, but it would be absolutely catastrophic to your entire finances. So we want to insure it. You're only insured to the $1 million level, but everything above $1 million is going to take your account out. Now, if this was it was not 11 million and you were at 50 million, $60 million, then I'd say you could probably take that risk or you could at least evaluate what that risk looks like. But I don't know why you would, because the reality is you could go and pick up an ACA plan off the marketplace, pay your $20,000, $30,000 a year for your premiums on it, still have your high deductible, but you don't have the cap. And then you throw the concierge medicine on top. So that way you don't even have to use the network that you're going to be dealing with from the ACA side of things. That's the cleaner way to do what I think you're trying to do here, and which is the more common approach to how you handle health insurance at this level of wealth. You're going to go with something that straightforward, big deductible, so it lowers your premiums. You're also young, so you don't have any concerns there. And then you stack that with an unlimited coverage for a cap that would be covered by the ACA. And you say, well, I want to have more options for doctors. I want to have the longer visits like you're talking about. I want to have better access, all that. Wonderful. Put the concierge medicine on top of that and stack those two together. A lot cleaner, a lot simpler, and you truly, truly avoid that cap for that catastrophic coverage. If these scenarios sound like you, that's exactly the kind of planning work we do every day at Scholar Advising. Visit scholaradvising.com to see how we help families bring clarity to complex financial decisions. And next, in our From the Field segment, we explore what causes trust and estate plans to unravel when family dynamics and ambiguity collide. Today, we're joined by Ellen Morris. Ellen focuses on trust and estate litigation, has extensive experience handling complex estate disputes. Ellen, welcome to the Scholar Wealth Podcast. Why don't you give us a little bit of the background here, how you got into this and what are the types of things that you end up doing?
Sure. Thank you for having me. Happy to be here. Gosh, how did I get into this? Well, I was a prosecutor when I first graduated law school for Janet Reno in Miami-Dade. And when I left there, I was a felony A prosecutor. So extensive litigation experience. When I came back after being home a little bit with the kids, I have three girls, I got into elder law. And a natural progression from elder law, I'm a past chair of this elder law section of the Florida Bar. So a natural progression was litigation involving, I'd say, issues in areas of law that affect seniors. A lot of times that's guardianship, estate, will contests, and trust litigation. So we call it by the broad term of fiduciary litigation.
So when you get into all this experience you have on the litigation side and everything, what are the common types of disputes that come up? Like what are things that you see, like another one of these? I've dealt with 1,000 of these scenarios. This is what it looks like. What
Sure.
does that look like?
Well, so let's just say when the individual, let's say a vulnerable adult, believe it or not, the exploitation statute says a vulnerable adult is anyone from age 60 and above. So that would include me. I don't think I'm vulnerable, but to give you the broad sense of what we tried to capture here in the state of Florida, it's 60 and above. So if we're talking about, let's say, during lifetime of a vulnerable adult, we're talking about fiduciary litigation that involves durable power of attorney, breach of agency under that durable power of attorney, a healthcare surrogate, breach of agency under the healthcare surrogate, guardianship, if there are no documents, living will litigation. I believe the plug should be pulled versus I believe the plug should not be pulled. So that's, I guess, in a nutshell, during life, let's say, for litigation. And then after death, it's will contests and trust contests.
Gotcha. So when you start to see these trust disputes and disputes, wills and all of this, one of the most common things that gets thrown around is, well, if you have a revocable trust, then you don't have to worry about those types of concerns. Because if you have a will, it can be contested, you have all these issues. But as long as you have this revocable trust, then all problems go away. And that doesn't seem to be the case as a maybe it's a broad generalization there that gets thrown. But can you talk a little bit about why is that the common thought and what types
Sure.
of protections are there? Is there any protection from the dispute aspect there or any
So
strength, I should say?
no, there's really not. So I think it's more of what you said earlier to avoid probate and also to create a succession process for your successor trustee to seamlessly take over the administration of your trust. And avoiding probate is a good thing. But I always say probate is not a four-letter word. There's a lot of reasons and situations where we actually want a probate. We want a court order and we want a probate. People think probate is just the devil. And yes, it can cause a delay in the distribution of assets. And yes, it can cause a dispute, but that's sometimes not always the reason not to have a probate. I'll give you a perfect example. For a qualifying special needs trust, this is a little technical, but for a qualifying special needs trust, when one of the spouse is going on to Medicaid, that qualifying special needs trust must be contained in a will. And if the surviving spouse, who is supposed to be the healthy spouse, dies first, there's a probate. And that's how you still achieve Medicaid for the surviving spouse. So that's just one good example. But to answer your question about trust disputes, no, that's just not the case. Trusts do a lot of things like avoid probate and include a mechanism for a successor trustee to seamlessly take over. But what they don't do is when a trustee is breaching their duty as a trust, the fact that there's a trust doesn't help with that. In addition, trusts are still subject to the allegation of undue influence. My brother or my sister took my parents to a lawyer and had my parents sign this trust when they didn't understand what they were signing. And he or she was influencing them to sign this. And, you know, this person, the influencer, benefited. So the other sibling might bring an action saying this trust is invalid because it was subject to duress, coercion, undue influence, or strictly lack of capacity, lack of testamentary or contractual capacity for the individual who's signing the trust to understand what they're signing.
So, do you find then that there's more kind of internal disputes between families on the trust distribution? Obviously, the trust doesn't help that compared to a will, but with different types of privacy benefits of the trust, do you see less disputes from, I guess you'd call them like outsiders or kind of extended family when you go through the trust because of the privacy aspect there?
So I'd say yes, most of the disputes are inter-family disputes. If you were another family member or a neighbor or someone else who was potentially a beneficiary of a prior trust document, though, you could still have standing
Mm,
and
okay.
you could still bring the lawsuit, and you then would still in discovery potentially obtain a copy of the trust document, etc. So it depends on the dispute. Trusts are great from a privacy perspective as far as the terms of the distributions, because your will, even though you may not have a probate, your will under Florida law must be deposited with the clerk. But if your will doesn't say a lot and it just says everything that I own in my name pours into my trust, and all the terms for distribution are contained in the trust, those terms for distribution will not be publicly available for anyone who wants to search the probate records, because wills are available to the public. They're not confidential. So that privacy exists, but it depends on the other privacy as far as discovery and other individuals getting copies of the trusts.
Gotcha. So that's when, if you're out there saying, Susie's going to get $1 million from my estate, then that's the privacy aspect that you're going to lose. But if you just have it split up to where everything's going to the trust and maybe it's divided out that way, then you can still gain that privacy aspect from the will, or at least not be as concerned about the privacy concerns about the will.
Correct, right. So if your will says Susie is getting 100,000 and somebody, a creditor of Susie's, might be very interested, they might think that Susie may be inheriting this money, and they may be very interested to know
Yeah.
when Susie's getting that money. If that's not in the will and it's all contained in the trust is not filed.
Gotcha. And what are some of those early warning signs then? So when you're looking at a trust or a will and you're looking at some of these documents, because I'm sure you get obviously brought in and you didn't create all of them that are there, and you're looking at it and saying this is going to be a problem in the future. What are some of those signs where you're looking at it saying this is probably not going to end up well in 1, 5, 10 years down the future?
So I'm in a unique position because I'm a planner as
Yep.
well as a litigator, right? There are some who are just planners and others who are just litigators. I actually think it's very beneficial, no matter what you are, a planner or a litigator, to have some knowledge of the other, so that if you're planning documents, you're keeping that in mind. If you're
Yep.
litigating documents, you know what to look for. So the early warning signs: one child or individual completely immersed in the planning conversation
Mm.
is one. For instance, that child or individual choosing the lawyer, which is a different lawyer maybe than mom or dad had for years, setting up the appointment, holding the documents. These are called Carpenter factors. They're based on a case in Ray Carpenter, which is a seminal Florida case that listed 7 factors where the burden of proving undue influence would shift to the alleged undue influencer, right? Because it's hard to meet that burden. Stefan, let's just say, your sister lives close to your parents
Yeah.
and
Yep.
she did all this. She got your parents to change the trust, gave her, instead of 50-50, gave her 70 and you 30, or even worse, 100% and you 0. And all of this planning happens behind closed doors, right? Like, let's say your sister lives near your parents and you don't. And your sister goes to the attorney and she's involved in all that. And then you find out after your parents die that this is what happened. Well, now you've got to go back and prove that your parents were subject to diminished capacity during that time. Maybe they had some memory issues. Maybe there's a neurologist or a primary physician, et cetera. Prove all that. And then you've got to prove your sister's active procurement. Well, proving active procurement, which typically happens behind closed doors, you weren't involved. You
Yeah.
didn't know that she brought them to another lawyer. You never asked. You figured, oh, you don't need to know about your parents' assets. They're alive. They're good. These things that happen behind closed doors, if the factors, enough of those Carpenter factors are there, then the burden of proof shifts to your sister to prove that she didn't unduly influence your parents. And that shift is huge. So those factors are what planning attorneys or litigators who are also doing planning should take into consideration. Make sure that the testator or the grantor is speaking to you, freely. Make sure there's no one in their ear, in the room, and make sure that they speak back to you what they want. I even do a very basic capacity test. I ask verifiable fact questions, and I train my younger associates and junior partners to do the same. Making a will is the lowest form of capacity required. I mean, as long as you know who your kids are, the natural objects of your bounty, for instance, and approximately how much you have. Oh, I have an investment account and a bank account and a home, let's say. That's enough to execute a will, but it may not be enough to execute a trust, right? Because the trust is much more complicated contractual documents. So the trust has a few testamentary provisions in it that testamentary capacity would apply to, but does the capacity to execute the rest of the terms of the trust, which are contractual, not testamentary, does that meet the litmus test? And then if you're not sure, if you're really not sure, get a doctor's letter. Primary physician or a neurologist or a neuropsychologist, very close in time, who's going to say, "Yeah, I know this patient, I've examined this patient, and I believe that they understand what they're doing and, are capable of exercising these documents."
Gotcha. And that kind of goes into another question that I had. And I think you hit one of the main areas that tends to come up a lot. And I'd be curious if that it comes up with you as well. Is let's say you have multiple children and then you have one child who is kind of more in touch with finances, doesn't mind looking at the legal stuff. And they are the ones picking the attorney for the planner for their parents. They're going to the meetings. They end up being put as the trustee on everything, right? They have all these responsibilities. And then post distribution, right, and everything's being out, then you have other siblings come out and start to have this kind of either or the real or perceived like unfairness that's going on. How do you get away from that? Or is this just a necessary burden that gets put on the the child that's running the finances? Because I know I've seen this where it's you have one child who's not good with finances and they're not the ones that the parents really want being in charge of the trust. And then they have another one that they say, yeah, this is great. We want to put Billy in charge of the trust. He's going to be the trustee. He's going to handle everything. He's already talked to the attorneys. We've had him in all the meetings. And how do you balance those? Or is that just part of that, the issues that come up where the intent is good, but still tends to cause more disputes later on?
So I guess I'll say if Billy is not inheriting more and is not benefiting from the position, right? It's a 50-50 split between Billy and Susie. Billy's the trustee, but he's not even taking any compensation
Yep.
for serving as the trustee, then no problem. And that to me would be like the utopia, right? The
Yep.
perfect family. Billy and Susie get along, everyone agrees, no one's pointing any fingers. That's great. I thankfully have a brother who lives in California, and we thankfully have that relationship. But there are ways that you can sort of bring everyone into the fold. It just depends on the settlors, like the parents. So sometimes I'll say to the parents, hey, how about we invite Susie to the meeting? And you don't shrink away from that, you know, that hard choice where you say in front of Susie, hey, Susie, listen, we're including you in the meetings, but just so you know, we're naming Billy to be the trustee. You know, you have had a lot of trouble with spending. You know, you don't have the same spending values as we do. You have a lot of Gucci purses or whatnot. And, you know, Billy is more in line with our values, or he's a financial planner, or he's attorney, or he's this, or he's that. And we're making it fair, but we want to include you. So, you know, so it depends on, you know, the bravery of the settler. If if they're my client, I try and empower them to be brave because it's their decision. Susie may not like it, but it's almost better to flush it out, you know, early when mom and dad are completely capacitated and they're expressing to Susie in front of the lawyers and Billy what their reasoning is. I mean, that would be the best way to do it if you're not sure that you have the utopian family.
Yeah. I think you have people squirming in their seats right now thinking about having that conversation, but I completely agree. Having that out there up front, it's a lot easier to have those conversations and potentially avoid those, or at least mediate those disputes
Let,
while you're
let,
still living. Right.
and let's say they don't want to do that, or let's say Susie gets angry and et cetera. Well, at the end of the day, it's still their decision. As long as they're
Yep.
capacitated and there's no undue influence, it is their decision. I mean, we do the same when it comes to tangible personal property, like artwork or even things that aren't of value, but are of sentimental value around the
Yep.
home. My advice to everyone, all of my clients is, you know what, take your kids, walk them around the house and see if they can agree. Okay, I'd like this. We use like, you know, those little circles of red, yellow, blue, green, etc.
Yep.
You know, all red would have an E for Ellen, and, you know, all blue would have an S for Stephan. And you'd go around and you'd put them on where you want. And then you just make a little list. And, you know, Ellen wants this. Stephan wants this. This is the stuff that they both want. And we're going to agree that, you know, these items will be chosen by picking of straws or numbers
Yeah.
in order or something like that. Because you'd be surprised how much tangible personal property, which isn't even the most valuable part typically of any estate, causes the most in attorney's fees and the most litigation.
Yeah, I completely believe it. It's where the sentimental value starts to come in a lot when you have those or the vacation homes and
Sentimental value, and it's Billy saying, I don't like how Susie called me names on the playground when we were 7, and this is the principal, or vice versa. So, yeah.
and what are some other area where do you typically see that disconnect happen between intent and the disputes? Because you hear these stories, and I know you've seen them where the parents had good intentions. They wanted to do this, but then it becomes a problem later on. Is it mostly due to ambiguity of just not being as specific as you're saying?
I think ambiguity is a big one. If it's not spelled out like we discussed, that's a big
Yeah.
one. The other reasons are motive and opportunity. Like if you have a child or nephew, family member or neighbor who sees the opportunity and has a motive of gaining an edge financially, control, etc., and you have a weaker minded settlor, testator, it can be there too. So maybe it's not ambiguous. Maybe it's totally spelled out, but it's skewed very much in favor of that individual who saw opportunity and had a motive. And maybe that's more of a criminal way of of describing it, but exploitation does have criminal penalties actually. And it can be sinister to that degree.
Do you see that type of shift when it comes from if you think kind of a living power of attorney, right? And someone is more of like a guardianship type scenario or power of attorney scenario, and then kind of post death in the estate process, there's still a responsibility, right? Of the either of the trust or of the person. Do those types of issues change later on? Like you hear the guardianship stories of they need some money and happens to be that mom and dad's money's right there and it's easy to use. And now there's no records for how the money's spent. Is it the same, but it's just now it's out of a trust? Or is there a different type of kind of
Yeah, it could be.
communication breakdown or governance issues that occur in
Oh, it
that
can absolutely be
transition?
the same. Because if there's a trust and the person is the trustee, they can breach the trust under the guise of, well, mom and dad said I could take this money. So it can be in a trust. And sometimes that's why you need a guardianship, even though there may be other documents like a trust or a power of attorney or a healthcare surrogate. You may need a guardianship, and you may need either a court appointed professional guardian or someone else to be the guardian, because you can end that nonsense, I'll call it, that inappropriate behavior, spending actions, etc., in a guardianship.
So when I look at all the things you've been saying, I'm getting communication between family members pre and post death, right? Being able to explain that and mitigate, reducing as much ambiguity as possible, and increasing communication around when distributions are being made, why they're being made, kind of even by the trustee, not necessarily by the parents. But looking back at your all the cases you've done and everything, what do families and even advisors most underestimate when it comes to these disputes or how they unfold? What are some common misconceptions there as we kind of wrap up today?
I think families and advisors probably underestimate the angst between siblings, sibling rivalry, and how strong it can be. And I think parents definitely underestimate, oh, my kids, they'll be fine. They'll work it out. They'll get along. Or, Billy will take care of Susie. I trust him to take care of Susie. Or an advisor also not digging a little bit deeper into that, maybe not knowing that Billy or Susie have a disability, some form of a disability. That's the reason for the disparate distributions. Maybe Billy had a disability to the point where he really was not able to get a good job, as well paid of a job as Susie, let's say, and parents were helping him along because he needed it, and documenting that, documenting that, because when you can show the pattern and you can show one of the factors, the Carpenter factors that I talked about, is the reasonableness of the provision, the reasonableness of the change. So if you've got the facts documented to support the reasonableness, that is key. That is clutch. So advisors and families should speak to each other about all of that and not underestimate sibling rivalry or sibling jealousy, the green eyed monster, to quote from a Berenstain Bears book that my kids and grandkids read.
This has been a great conversation. I really appreciate you sharing some of this and hopefully maybe extend some bravery out there to those who are looking at having these conversations or trying to prepare for those conversations in the future. So thank you so much for coming on today. It was a pleasure.
My pleasure. Thank you for having me, Stephan. Good to talk to you.
Likewise.
Take care.
That's our show. Thanks for listening, and we'll see you next week.
The information provided in this podcast is for general informational and educational purposes only and is not intended to constitute financial, investment, or other professional advice. The opinions expressed are those of the hosts and guests and do not necessarily reflect the views of any affiliated organizations. Investing in financial markets involves risk, including the potential loss of principal. Past performance is not indicative of future results. Before making any investment decisions, you should consult with a qualified financial advisor who can assess your individual financial situation, objectives, and risk tolerance. Thanks for listening.